Okay, so hello everyone. So this is the part second of 2020 previous year law optional paper. Now in the part one, I discussed question number one, in which we have 5 questions, right? So I discussed 5 questions in part one. So today I will be discussing question number 2, which will have again further 4 questions sub part attached to it. Okay, so let us see part 2 of the paper 1. Now if you will see question number 2 that have 4 subparts, right? So you will find that the first question, right, that relates to that is your question number 2(1)(a)(1). Okay, now what it said, it says that discuss the power and the functions of Lokpal and Lokayukta under the Lokpal and Lokayukta Act 2013. A very straightforward question, right? What is the power and function? And the second part of question that is very relevant is that how do you think that the office of Lokpal is better than other anti-corruption mechanism? So it means you have sort of a compare between the other mechanism that is available, and you have to justify that why it is much more better than other mechanism. Okay, right? So that is the demand of the question, right? So I have given here itself that introduction you talk about very general meaning, purpose of having a Lokpal Act, why the other mechanism deems to be insufficient, right? Not in detail, but normally that acknowledging the the realization of the limit of the previous established anti-corruption mechanisms such as CBI, CVC, etc. The legislature came up with this particular act, right? And there have been a demand in history, right? So you simply write down its evolution, right, and its significance, right? And then you go to the detail of the Lokpal and Lokayukta Act. What is the function of Lokpal, how they are appointed, function of Lokayukta, how they are appointed, okay, how they are independence is ensured, etc. Okay, those sort of stuff. And then you compare it with other mechanism, right? Because this question, if you will see, is a 10-marker question, right? So hardly you have 150 words to write. Okay, so this history part 30 to 40 words, that is your 6 to 7 lines. Okay, this part you hardly have 10 to 12 line to write with regard to structure and function, right? And then 10 to 12 line you have to write with regard to its comparison with other mechanism. Okay, so you have to be very wise in the choosing of words, right? So instead of writing point by point in a very detailed manner, you should write point in a very brief manner. Okay, but I have given here sort of a model answer, right, that why this was provided, okay, as a helping of people, right, rationale behind it. Then the structure of Lokpal, I have given all of them, right? The purpose is that even if you remember 2-3 of them, that would be sufficient if the same question comes. Okay, right? So the answers are designed in a way that any type of question related to that concept you should be able to answer. Okay, similarly power and function, in terms what is the main power and functions, right? So top 3 is the major one. If you want, you can remember those itself, right? And then you have to talk about and the same thing is with the Lokayukta, right? So Lokpal differently and the Lokayukta differently, right? So even if you remember top 3, that will be more than sufficient. And the main thing is that advantage, right? You have to compare, you have to give a separate heading, and you have to talk about the advantage between them. Okay, now the advantage between them, right, is with regard to CBI, I have given here, right, and the Chief Vigilance Commission. Okay, both of them, the primary lacuna is that up to a particular post they can inquire, right? So the political executive, they actually cannot inquire, right, unless they are allowed by the political executive itself, right? So that will be a sort of a never happen, right? Chief Minister will never give a sanction to inquire against themselves. Okay, so that that was the lacking thing in that, right? But that is how the Lokpal becomes different in that aspect, right? So that is the primary difference between Lokpal and other anti-corruption mechanism. Understand that particular point, right? The one difference is with regard to removal of their head also, right, or the appointment of their head also, right? CVC heads, CBI chiefs are totally prerogative of executive, right? Although there are some mechanism that Chief Justice will be the part of that committee recommending, etc., right? But that is not statutorily defined. In the Lokpal and Lokayukta, it is statutorily defined. Okay, so that is gives them a very edge over the other anti-corruption mechanism, right? So you can write these two major difference, that will be more than sufficient. Okay, now let us come to question number 2, very traditional question, multiple time repeated in the law optional paper, right? Pardoning power, examining how far judicial review can be exercised over such power, right? So to explain the pardoning power, with respect to the president, he can only pardon, right, in the case of the punishment which is given to an accused convicted person with regard to a union law, right, and death in any case. Similarly, that is the case in the governor, right, that only with respect to the the pardoning power of the governor will be only applicable with respect to those laws in which the executive power of the state extends. Okay, except death, right? Death, in that case he can pardon. Okay, now Second part of the question is that what is the judicial review part of it, right? Judicial review, right? Now, as we all know, what is the nature of judicial power of the executive? It have been given as a last relook. It is not a retrial, right? So the nature of the judicial power would be that it is merely coming to a new conclusion based on same judicial record, right? So they cannot alter judicial record. That is the crux of the judicial power, they say, that they exercise. Okay, they cannot override decision, in the sense by altering the judicial conclusions. Okay, I mean judicial records, right, evidence, etc., etc. They cannot do that. Okay, they can simply reappreciate the evidence. That is what they can do, but they cannot alter, right? So judicial records cannot be altered. Okay, so that is the that is that exercise of that judicial power will be necessarily a discretion, right, subject to the judicial review by the courts. Okay, so it is not an absolute power conferred upon them, right? However, the scope of that judicial review by the court will be limited, but there will be. Okay, so that you have to mention. That is what I have written here also. Okay, introduce the nature and the power enjoyed by the president, the nature that I have discussed, right? And list down the constitutional provision, right? Go on the constitutional provision with regard to president, right? And then again discuss the nature and whether with regard to judicial review, that whether it will be judicially reviewed or not, or what were the grounds of the judicial review. I told you it can be judicially reviewed, so the ground you have to write, right? And the case law with regard to them, Ipuru Sudhakar, very famous case with regard to that. Okay, and then you conclude generally, right, commenting on the nature that, okay, whether it should be allowed or not allowed, not in a very 2-3 paragraph, no, just write in 1 and 2 lines, right? Like you could write that executive clemency, although it is a judicial power, the real nature lies in its executive discretions. Okay, because it is exercise of basically discretion itself. Okay, so very generically you conclude 1-2 lines. Okay, that is what I have given here also. You can see judicial power of the president with regard to what constitution provision. This word, this you need not to write in exam, but here I have given you just to understand. And then the case, the most important case is basically Ipuru Sudhakar, right? I have given other cases also, but this Ipuru Sudhakar case is very important. You must have seen the state of Andhra Pradesh. There was a Congress government at that time, right? And the governor actually pardoned a particular person, writing that in the reasoning that they are very good Congress workers. Okay, so the court said that cannot be a reason for pardoning someone. Okay, so that's it. And then write the ground of judicial review, and that is provided in the case of state of Haryana versus Jagdish, right? This pardoning power is not unbridled, right? Which means it is subject to judicial review. Okay, so very simple. Now let us come to question number 2b, that is the third question. Now the third question is a little bit very interesting, right? That is the distinction between quasi-judicial and administrative function is no longer an exclusive criteria for deciding whether or not the rule of natural justice would apply. Critically examine the statement. See, normally only in the case of administrative function or administrative discretion the rule of natural justice will apply. Because the assumption is that when you have a judicial function, only pure judicial function, by default the principle of natural justice is inbuilt into the procedure, right? Like for example, if a judge gives a decision, right, then by default the natural justice principle is inbuilt in all the criminal and the civil procedure code. All of them is inbuilt, right? Right to notice, right to question evidence, rebut evidence, etc. Every principle of natural justice is inbuilt in that. Okay, but the question, this question demands that judicial thing, it's okay, right? But what about quasi-judicial? Do quasi-judicial also, we can in the quasi-judicial function we can assume that the principle of natural justice is inbuilt? The court have held nowadays no, right? So that is what the question is, the distinction between quasi-judicial and the administrative function is now no longer a valid criteria for deciding, right, for judicial determination that whether the rules of natural justice will apply or not apply. Understand that particular point? Okay, quite simple. How will you approach it? You will first talk about natural justice in general, okay, and why does it apply to administrative discretion? Okay, because to prevent tyranny. Okay, then you will write relating to administrative law, administrative discretion it applies, what are the grounds, 2-3 grounds, and then quasi-judicial action and the administrative function and the difference between them, right? And then how this distinction is now irrelevant. Okay, here I have written it is relevant or irrelevant, right? But for in this particular case it will become irrelevant. Okay, and then you have to conclude, right, with regard to why this differential treatment of these two type of actions have been obliterated by the courts. Okay, so let us see the first principle of natural justice, quasi function and whether purely administrative function ek Kirpalak, very famous case actually ek Kirpaik, okay, with regard to administrative law. Then application of rules of natural justice is the only criteria. Obviously the answer is no, okay, and then you have to conclude that why it is so, right? You can write that even though there is administrative discretion, right, administrative action, right, and even though some judicial proceeding is provided, right, still it cannot be considered as a pure judicial proceeding, because they are not governed, right, by the civil or the criminal procedure codes, okay. In fact, we will see that recently multiple tribunals are built where it is written that they will simply follow the rules of natural justice. They don't even say that you will follow the the procedural laws that is there in the country, okay. So that becomes a very relevant point. You can argue that also, right, that even though there is a administrative discretion which done by a quasi judicial body, still in the law itself it is written that they must follow the rules of natural justice, right. So it means that legislature itself sort of yielding to the fact that even if it is a quasi judicial function, right, the rules of natural justice must apply on that, right. So that also you can talk about, okay. Now let us come to 2C, that is your fourth question. Now if you look at this 2C, right, it says, with the help of illustration, discuss and differentiate between cooperative and competitive federalism. Very interesting question, right, because this question have been asked again, right. This was there in 2017 also, I think there was one paper question on that, right. What is the difference between them, right? So I have given the difference, but let me try to make you understand. See, cooperative federalism simply means that there are suppose 3 layers of the government, right, 3 organs and 3 layers, okay. We have union layer, we have state layer, and we have layer with regard to local government, right. Now when we talk about cooperative federalism, it means cooperation between different organs among themselves, right, at this level, okay. Union executive is cooperating with the state executive is cooperating with the district executive, okay, local executive. Now when we talk about competitive, and constitution provides, so there are multiple provisions you might cite, right, like the existence of interstate council, right, interstate river dispute tribunal, etc., right. But in the case of competitive federalism, you can write that after liberalization, 1991, right, the resources are limited, right, that the state needs to compete among themselves as well as with center, right, in order to have utilization of, or in order to procure those resources, because resources are limited, okay. So you can say that competitive federalism is more of a economic concept than a legal concept, right, competitive federalism, okay. Now that I have given here also, you might say, see here, see the competitive and the cooperative federalism, right, I have written also, it refers to vertical and the horizontal relationship with the state. The state not only compete among themselves but also center for the benefit, right. That is the crux of the competitive federalism, right. You have to expand on that idea itself, okay. So that is how you will answer the answer, or you will introduce the concept of federalism, and you will write that how it have been diluted. You can cite constitutional provisions, right, and then you can talk about the difference between them, and then you can give the examples, right. You give the examples, right. Recent Finance Commission recommendation, right, that is totally in the line of competitive federalism, right. They have had some parameters that if you follow it vis-a-vis other states, then only you will get that much amount of money, okay, that is resources, okay. So you can say that now the era is going to cooperative to competitive federalism, okay. The state will not say that, okay, in the spirit of cooperationship, or in the spirit of cooperation, I will not ask for any resources. No, not at all, okay. So that have been introduced, right. And competition, I think, is the best way of distribution of resources, right. Don't you think? It is a capitalist idea, but that is a good idea, I suppose. Okay. Now here you might write one of the viewpoint, being very diplomatic, that there has to be a perfect mix of both of them, okay. So you can conclude recently with GST bill, okay. So GST is an example of cooperative federalism rather than competitive federalism, okay. So this question is more of a GS paper 2 nature, and you have to write accordingly, right. Don't think that it is a law optional paper, then you cannot write GS paper 2 type answer, not at all. You need to write it down sometime, okay. Done. So that will be all. Thank you.